forward with this presentation we have today. Anyway, we're going to go ahead and let's hope all my computer works the way it's supposed to. There we go. Since we can't really see each other and I'm used to doing live presentations, I just wanted to let you know a little bit about who I am, and that's my face. So my name is Vanessa Liddell. I'm actually a real estate coach and consultant, and I specialize in short sales. I have had my own short sale processing company, and recently for the last couple of years I've been a short sale trainer with the CDPE program and have traveled all over the country working with, I think I've trained about 7,000 to 8,000 agents in the short sale process. I've been involved in the industry through title and escrow for about 27 years, and I really enjoy working with agents, especially here in California, in this interesting market that we're having to deal with. But enough about me. Let's get into what you're here for today. I had the opportunity of speaking with Lisa when I first had a chance to meet her and going over to your office, and we were just discussing, you know, this new thing that's come out called Mars. And my big joke is who's heard of Mars? And, you know, it's not just the planet. So what we're going to talk about today is Mars, which is actually the initials stand for Mortgage Assistance Relief Services. Now, just to give you a little background, the Mars rule actually was created, came out from the FTC, which is the Federal Trade Commission. And to let you know, the Federal Trade Commission is basically a governmental agency that's set up for specifically one thing, and that is consumer protection. So you'll see a lot of information about the FTC coming in, and I think they just gave, like, you know, $1.2 billion back to consumers because of some fraudulent event or something. So the FTC is basically out there trying to protect consumers, and of course in this day and age when we have, you know, so much fraud and everything going on, that they felt like they needed to get involved in this market here. So anyway, Mortgage Assistance Relief Services, the FTC rule came out. Now, it became effective December 29th of 2010. And just to let you know, it is an extremely big, broad rule. And when I say that, what I mean is it basically encompasses any agency, organization, company, individual that purports that they can assist distressed homeowners in preventing foreclosure. That's what this rule is all about. So when we talk about the rule itself, you're talking about, you know, like modification companies. Even attorneys are involved in this requirement for compliance. Real estate agents, brokers, we're going to be talking about, you know, you guys specifically. Companies that, you know, say that they, for a certain fee, that they can keep people from going to foreclosure sale. They, you know, they stall the trustee sale and things like that. So this is a huge, huge, broad rule that came out for protection. So some of it may not feel as comfortable with regards to it only relates to real estate, and you'll kind of understand that when we start talking a little bit more about the disclosures that are required. But it became effective December 29th of 2010. Unfortunately, we didn't hear anything about it for a couple of months, but the rule itself relating to especially real estate requires 3 specific disclosures, and we're going to go over those individually today. Some record-keeping retention rules and creating some procedures to ensure compliance. And just so you know that this is a kind of a weighty obligation, rule, federal law, whatever you want to call it, the violations for noncompliance have been cited at anywhere from $11,000 to $16,000 a day per occurrence. And just so you also understand, the FTC, the policing agency, the governing agency for the FTC is Attorney General and when I say this little group of guys running around with 3 letters on their chest, the FBI. So they're the ones that investigate, prosecute, and all this other stuff. And you know, those are the compliance police on this. So December 29th of 2010, the rule came out. We really didn't hear anything about it. I have quite a few attorney friends across the country that I've met, you know, in the last few years, and I knew it was out there. I read about, you know, agents and brokers being involved, but I didn't hear anything until finally on February 23rd, when NAR, National Association of Realtors, announced that the Federal Trade Commission's staff's position is that real estate agents who negotiate short sales with lenders, along with those who promote their services as a way to help consumers avoid foreclosure, must generally comply with MARS, which basically the full effect of MARS came into being on January 31st of 2011. So not to make you nervous, but I think today is what, May 11th? So if you haven't been compliant with MARS or you didn't know about it or whatever, basically at this point in time, you're almost 4 months out of compliance. So we want to make sure that you understand, you know, the requirements and what you have to do in order for you to become compliant as you move forward with your business. All right, so let's talk about the disclosures that are going to be required. Now, the CAR just came out with 2 forms, and we will go over those also. But what I need you to understand under MARS is there's actually 3 disclosures that are required in the rule, not just the 2 written forms that CAR came out with. I mean, it's great CAR came out with the forms, even if it took them a couple of months to, you know, to do it. But there's one more disclosure that you have to be very aware of, and that is on promotional advertising. So the rule itself says, and this comes straight out of the 45-page rule if you're interested in getting a copy of that, it says a real estate professional that advertises MARS services, which is not directed at a specific consumer. So what that means is that if you're sending out materials or advertising to the general public, the other 2 disclosures will have direct relation to a direct transaction, like you have a client that you're working with. This first disclosure is to general public. So not directed at a specific consumer. We'll need to include in all advertisements a clear and prominent disclosure with the following. Now, it's in red, and this is exactly what the disclosure needs to state. I mean, this is what they're saying it has to state. So it has to say, important notice, that needs to be bold, and you can see how specific the disclosure has to be because they've actually said it needs to be in 2-point type larger than the font size of the disclosure. So in other words, if you make your disclosure really, really small, like in a 6 font, then the important notice has to be bold in an 8 font. I mean, that's how specific this disclosure is. Goes on to say then the name of your company is not associated with the government and our service is not approved by the government or your lender. So right there you can tell that this disclosure is basically saying anybody out there saying that they are, you know, they come with the government's blessing, the lender hired them to contact you, whatever it is, they're saying this disclosure is going to prevent people from being able to say that. So it's actually covering themselves basically. And they don't want to be responsible for anything agents go out there and say. So even if you accept this offer and use our service, and that means the offer of your service, not the offer from the bank. So, you know, you're offering to, you know, provide them a service. Your lender may not agree to change your loan. If you stop paying your mortgage, you could lose your home and damage your credit rating. So all this information is something you shouldn't be afraid of telling the homeowner. In fact, we should be telling homeowners that are in that situation that, you know, even if you accept, you know, even if you work with me, even if we can get the house sold, it doesn't mean that the lender will agree to give you a short sale, you know, stop a foreclosure, whatever it is. So this is disclosure. These disclosures, I believe, are very timely and they're important, and you shouldn't be afraid of them. You just need to kind of embrace the changes and be aware that they really are very concerned that consumers are not being told basically what their rights are. So promotional advertising. So what does that mean? That means every brochure, every flyer, every postcard on your website, anything that you send out that has specific language that says, I can give you information to help you prevent foreclosure. If you're having trouble making your payments, call me. I'm a short sale specialist, call me. Anything that goes out that has anything to do with relating to distressed homeowners. Because FTC, you know, the reason this didn't come out until February 23rd with NAR is NAR was actually fighting with the FTC. Their attorneys were going back saying, you know, this has nothing to do with agents. We don't go out there, you know, basically they were saying we never give out the wrong information. We never misrepresent, you know, any of that. And the FTC says, okay, fine. we will agree that agents and brokers will be exempt from this rule as long as you don't say you do anything other than 1, you list property, 2, you sell property, and 3, you negotiate offers between buyers and sellers. If you don't say anything else, then you're exempt from the disclosure. Okay, now let's get back into reality as we see it. There are very few agents out there that are only selling, listing property, as they used to do normally, that are not involved in some sort of either short sale, working with people that are saying we're looking to modify our loan first, and then if that doesn't work, we want to do a short sale. Whatever it is, if you're working with somebody who's in distress, this applies to you. So, and statistically, right now, depending on your market, we've got 40% worth of distressed properties in a lot of markets. The statistic just came out that out of all the sales across the country, 48.6 were distressed properties, which is an REO or short sales. So if you're doing business, more than likely you're doing this type of business. So this is going to apply to you. So websites, postcards, brochures, door hangers, whatever you have out there that says anything other than just regular real estate has got to contain this type of disclosure or this disclosure. All right. Let's see. I'm not sure. I'm going to just check Lisa and see if she's getting any questions. So I just want to make sure we get everything answered. So, all right. So let's move on. Now we can always come back if there's questions. But let's move on to the next, the disclosure. If I can get my little computer to move forward. Come on. Gets frozen in its little mode. Here we go. All right. Oops. That was, okay. So now we are at the next required disclosure. And now this is, and this is one of the CAR forms. And this one is going to be the MARS. And it's MARSSN. And that form, that CAR form is now available, should be on your zip forms. And you can, obtain that form. This form is specifically for the listing appointment. So let's read what it says. It says, in order to comply with this disclosure requirement, a listing broker should provide this disclosure to the client in a letter or memo once he or she is aware that the transaction may be a short sale. What's good is that you have what's good is that you have the forms. So CAR, they came out with the forms, the MARSSN. So what that stands for is MARS, offer for short sale negotiation. Okay, and this has got to. I'm just looking at what Lisa's saying. Okay, Lisa, I got the message. We're good. All right, guys. So this has got to be taken care of at the time of the listing. So let's read what this says. And like I said, it's on the form. This is the information that's contained on the MARSSN. Again, important notice, you may stop doing business with us at any time. That's absolutely true for a homeowner on a short sale. You may accept or reject the offer of mortgage assistance we obtain from your lender or servicer. That is also true. Even though the SSA, which is the short sale addendum, that we use on all of our short sales, it says, and I think there's a little bit of a loophole there, but it just says that the contingency for the short sale is removed upon seller getting a short sale approval and buyer's receipt. It doesn't give the seller the right to accept or to reject the actual short sale approval, and they need to be able to do that. In other words, if you get a short sale approval in and it says, this, we approve the short sale with the seller giving us a $10,000 cash contribution. Just because you get a short sale approval does not mean that that contingency should be released. The seller needs to accept that, agree to it. And if they don't, what are you going to do? Well, you either go back and renegotiate the terms. You either renegotiate the terms, or the seller has, the seller rejects it. You renegotiate the terms, or the seller accepts it, understanding what the consequences are. So this is, this has to go along with that short sale approval, that if they get it, they have the right to either agree to it or accept it. So accept it or reject the offer of mortgage assistance we obtain from your lender or servicer. If you reject the offer, you do not have to pay us. Okay, that makes sense. If you accept the offer, you will have to pay us. Now, understand, we need to go back to the philosophy of how this law was written again. This was written, very large, broad rule for